Thank you. Thank you. Good morning, church. Praise God. Amen. Praise God again. Amen. You're right, this is all different. It's challenging, but we will do our best. We are used to sitting safely behind somewhere and just listening. So you have made sure we have come out from our comfort zone at the back there and come here. I hope it will be for a good reason. I am not Justice Muga Apondi, but it is my duty to introduce him. We go by seniority, the day you are sworn in, not how young or how old. So you can tell who is senior already. To start us off, we will have Justice Muga Apondi. I'll just summarize his CV. It's very long. And we will not say the years. We will leave you to guess. He's a holder of an LLB, that is a law degree. He's also a holder of an LLM, that's a master's degree. Definitely, he went to primary school and high school. He has also gone to the Kenya School of Law. He has worked in the Lands Office. He has worked through the ranks as magistrate. I'll not go through all those ranks. He is also an advocate of the High Court of Kenya, having completed Kenya School of Law. He's also Commissioner of Oaths. If you have affidavits to be signed, Notary Public. He's also a current member of the Law Society of Kenya Arbitration Committee. He's also a member of the Chartered Institute of Arbitrators. He's also one of those we call neutral experts, a professional mediator, and he's also the managing partner of Muga Apondi and Associates. Together with that, he has also experience in teaching the law. He has taught at the Kenya Police College, Kiganjo. He has also taught at the Judicial Training Institute. He has taught newly appointed judges, so you can guess what may have happened between us. He has lectured at the Kenya School of Law. He has also lectured at the Kenyatta University on ADR. He has also taught judges and magistrates how to write judgments. He has also taught procurement and finance departments on how to apply the law of procurement. And he also is one of the lecturers for Law Society of Kenya to train the young lawyers in professional career development. As I said, I have summarized. So let me welcome Justice Muga Apondi.
Good afternoon, church. God is good all the time? Good. Asante. Thank you so much, my colleague, Justice Margaret Muigai. I've known Margaret for a long period of time because we have worked together in the judiciary. I hope he has not bored you with the kind of introduction that he has given to the church. Now, following the decision of this church to try and educate the congregants on various issues and various challenges, the church decided to call different professionals. And they decided that we were going to be the first professional group to make a presentation in church. So we met outside here, and me being the oldest, as you can see, they decided to nominate me as their interim chairman. And graciously, I agreed. And for the reason is that I'm so much attached to this church. Since I moved to Karen about 13 years ago, this is the church I've always been attending. Previously, we used to attend All Saints Cathedral because it was much nearer to us where we are staying. So after deliberations, we formed a committee, and I don't know whether I can be allowed to introduce members of the committee. There is Justice Margaret Muigai. She's currently the resident judge in Machakos. And then we have, can the other members stand, please? They are actually, I'm being informed that they are actually ushering. So we have Evelyn Kendi. We have, I can see Evelyn is at the back of the church. I can also see Miss Awori. Miss Awori is a practicing advocate. I can see she's waving at the back. So we had deliberations, and then we decided on the kind of topics that we should present to the church. So after a lot of deliberations, there were quite a number of topics which came up, things which are very current and things which are affecting many members of this particular church. So for this particular service, what we decided to do is that we are going to talk about alternative dispute resolution mechanism, or in other words, called ADR. I'm sure most of you have heard about alternative dispute resolution mechanism, isn't it? And then there was also another group which was going to make some presentations at 8. There was also another group which volunteered to come at 9, because there are people who are what you call morning persons, and there are people like us who wake up a bit late, given our age. So we decided we'll pick on the 11 o'clock service, but we have some younger lawyers who are more energetic than us. They decided to come much earlier. That is for the 8 o'clock and for the 9:30 service. Now, for this group, for this presentation, when you are talking about ADR, it is a very wide subject. Even in the university, you cannot teach ADR within a period of 3 months, because it is quite involving and it involves a lot of things. So what we decided to do, me and my colleague, Justice Muigai, is to try and break it down so that it becomes easier, it becomes more enjoyable, and for the members of the church to be able to understand that particular topic. So after discussions, we agreed that I will only dwell on what you call mediation and negotiation. Whereas, on the other hand, she is also going to deal with arbitration. But in the event that I forget anything or I overlook anything, then she will try her level best to fill in the gaps. Apart from that, our approach is that when we have made the presentations, she will also try to link it with the Bible. Because like the second reading here today, you can see there were issues relating to some kind of harmony within families and within communities. Now, all of us know that during the colonial period, they brought in the system of the court system. The court system was not there before. But with the arrival of the colonialists in this country, they introduced the court system. And the court system is at different levels. You have the magistrates' court, you have the high court, you have the court of appeal, and ultimately now you have the Supreme Court. And over the years, the government has spent a lot of money to build more courts, to employ more magistrates, to employ more judges, And right now, I believe that almost every county, if I'm not wrong, with the exception of a few counties, have a high court station. And the ones which don't have a high court station, they at least have a magistrate's court. The whole idea is the concept of bringing access to justice, so that you don't have to travel so many miles in order for you to access justice. Now, magistrates were employed, and to the extent that the numbers have gone up. The numbers are now humongous. The number of judges is humongous. But the problem now is the number of cases are too many, and they cannot be resolved within a certain period of time. You have cases which have stayed in court for more than 5 years. Others have stayed in court for more than 8 years. And a few cases which have stayed for more than 10 years. Although the judiciary has tried its level best, but it is not possible to finish all the cases within a certain time framework. So that is the reason why this concept of arbitration, mediation, and negotiation came in. Because you'll recall that in the past, we used to have wazees, isn't it, who used to sit under the tree. Whenever there are any disputes, whether there is a problem about cattle rusting, whether there is a problem about land issues, whether there was a problem about matrimonial cases or about criminal cases, wazees would sit down, isn't it? And they will resolve those issues. So basically what we are saying is that alternative dispute resolution mechanisms did not start yesterday. They did not start before independence. These are things which have been there with us. The Africans have been using that mechanism because they knew from the word go the advantages and disadvantages of dealing with matters at a local level. I don't know if I may ask, have you heard in the village kwamba somebody has been called to the elders kwamba kijana wake amevunja msichana fulani mguu? It seems people know what I'm talking about, isn't it? And those things are not being taken to court. And you don't see people killing each other. What do they normally do? They sit under the tree. They sit down. I know those people who have been affected are not in St. Francis, if I may use the language that the pastor always teaches us. These bad things do not happen in St. Francis. People will sit down, they will agree. You are going to be fined 2 goats, you are going to be fined 2 cows, you are going to be fined 5 goats, and the matters will be resolved. In fact, in some communities, like even in northeastern province, you find even when somebody has been killed, those matters are still being decided in their home areas there, without necessarily the matter coming to the attention of the judiciary, to the attention of the executive. So that is how powerful mediation is. That is how powerful alternative dispute resolution mechanism is. Now, basically, most of you know or you have heard of a Council of Elders called Kiama, isn't it? You have also heard about Njurincheke. These are people who resolve a lot of disputes on the ground. I remember I had the advantage of mixing with members of Njurincheke when I used to work in Meru. and I think their chairman was somebody called Faris, but unfortunately he passed on. But he is somebody who was very energetic, and he would even come to court and even request that if he can be allowed to hold some sessions with some members of the public in terms of problems relating to land. Now, what is basically the basis of alternative dispute resolution mechanism? At an international level, Article 33 of the United Nations Charter, it urges all member states to deal with the disputes through a mechanism where war will not be blown out. They encourage member states to try and resolve their disputes through alternative dispute resolution mechanism. That is at an international level. That means the United Nations itself also appreciates the fact that peace must be maintained, and if you must have peace in the world, then you must have a process that is understood, a process that people can respect, a process that will not be costly. That is at the United Nations level. When we come closer back to Kenya, Kenya decided to promulgate a constitution in 2010. And in that constitution, and I'm sure most of you have seen a copy of the Constitution of Kenya, in Article 159, it says that the court has a duty and obligation to promote ADR, to promote alternative dispute resolution mechanism. Now, the court is the Supreme Court. The Constitution is the supreme law in any nation. The Constitution is more superior than all other legislations in the country. Now, it is on that basis that the judiciary took a cue and established what you call a court annex mediation. A court annex mediation is where the court itself, what it has done is to make sure that they have a number of mediators who have been trained to become mediators. Right now, if I'm not wrong, I think we must be having close to 2,000 mediators who are court annexed. And these court annex mediators have been put on that role so that if you have a case today in court, they try and sieve through a case. And they tell you, Mr. Kamau, Mr. Njoroge, this is a matter which can be resolved outside the court. Now, these mediators are put on a panel, and each time there is a matter which is filed in court, they call mediator number 1, mediator number 2, mediator number 3, and they tell the mediator to try and resolve that particular problem. This is because there has been a lot of congestion in court. And that is the reason why the judiciary has decided to have what you call court annexed mediation. Now, in terms of definition, what is mediation? Mediation is one of the alternative dispute resolution mechanisms which has been practiced since antiquity and is thus a restatement of customary jurisprudence. It existed before the other forms of dispute resolution mechanism were invented. Both mediation and other alternative dispute resolution mechanisms focus on the interests and the needs of the parties as opposed to positions. Basically, in mediation, what you are trying to do is to bring in a third party. You are having a problem. There is Kamau, there is Onyango. They are having a problem. And when they are having a problem, the first thing that normally most human beings would do is to negotiate, isn't it? You negotiate among yourselves. How are you going to resolve a dispute? But in the event that you are unable to resolve a dispute, then it means now you have to bring in a third party. Third party is the one now who will put you together, talk to each party, get your position, get her position, and see how you can be able to resolve that issue. So it is important when somebody is a mediator, what is he bringing on the table? A mediator is somebody who brings some kind of calmness, some kind of sense, some kind of confidence in the process. You don't want somebody whom you do not respect. In normal disputes, you find that even if you have a dispute at home, there are people you respect, isn't it? When they come, if it is your uncle, if it is your aunt, you can find that even the language of the parties now change. The mere presence of a mediator should be able to moderate even the language of the parties who are involved in a dispute. You'll remember a couple of years back, we had disputes related to the 2007 elections. And I think that is, at that particular time, almost every Kenyan knew the word mediation. Every Kenyan came to know that there was a distinguished diplomat from Africa called Kofi Annan. Kofi Annan came to this country. He was a distinguished diplomat. He was respected all over the world. And by then, he had already retired from the diplomatic service because he had worked as the United Nations Secretary General for a long time. What happened when he came? Kofi Annan was able to bring the warring parties together, and they signed an agreement. The reason was simple. Kofi Annan had the respect of all the parties. And each of the parties knew that Kofi Annan was an astute diplomat who had been recognized all over the world and that he was bringing some value on the table. His mere presence brought calmness, brought sense to both parties. And each party wanted to show Kofi Annan that they're not the ones who brought the problem. They now started talking as gentlemen. Kibaki was there talking as a gentleman. Raila was there talking like a gentleman. And that's how the peace process was combined, was somehow resolved. So it is important when you are talking about a mediator, you must bring somebody who brings value, somebody who is respected, somebody who can be able to convince the parties that it is not in their interest to have a conflict. Now, because of time, what I will do is just talk about a few advantages of mediation. What are the advantages of mediation? First of all, it is a voluntary process. That is, the parties themselves have agreed to go to court, to meet a mediator. Nobody has put a gun on the face of any of the parties. It is a voluntary process, and both parties have agreed to be subjected to the process of arbitration. Secondly, there is what you call autonomy. The parties are free. And they can make any decision. Thirdly, mediation process also brings what you call party satisfaction. It is a process where after the mediation has come to an end, you can sign an agreement and say, this is what we have agreed, and you can shake hands. The way after the post-election violence that we had in 2007, the parties shook hands and they signed an agreement. Fourthly, mediation, there is speed, expeditiousness. A mediation process can take a very short period of time. It can take even 2 hours, 3 hours, or 5 hours. In contrast to cases which have taken 5 years, 10 years in court, mediation can bring the parties together and they can sign an agreement on a single day. About a month ago, I was attending a mediation summit at Strathmore University, and one of the retired distinguished judges of this country was sharing her experience. There was a problem in court, and that problem had taken about 9 years. And then this file was given to this lady justice. What she told us really moved the parties, because she explained to us, and it was a family problem. There was a mother with 2 children, 2 daughters on one side. Then there was another side which had several daughters and some sons. They had differed. Your guess is as good as mine. The father had passed on, and there was conflict about properties, and they could not agree. What is interesting is that during the mediation, the tempers were very high. And the language that was used was not language which was appropriate. In fact, one of the daughters lost her temper and started referring to the mother as this woman. At that stage, the judge intervened and said, no, I'm not going to allow this. I'm also a mother. I also have daughters, but I'm not going to allow it. I'm stopping this mediation, and I want you to apologize. This so-called woman is your mother. Whatever differences you have had, I'm not going to allow it. After consultations, they went outside. Obviously, the mediation could not go in. When they came, the daughter agreed to apologize to the mother. I say, Mama, I'm very sorry. I lost my cool, but you are my mother, and I recognize you as my mother. From that point, the negotiations took a turn. Ultimately, a dispute which had been there in court for 9 years was resolved by 6:30 p.m. on the same day. Can you see how powerful mediation can be? There was also another instance which involved an Asian family where they had a lot of disputes, and still it related to property. The father said simply that there is only one condition in which we are going to resolve this dispute. Because when there is a stalemate in mediation, normally what you do, you have what you call a caucus. A caucus means now you are meeting the parties on different forums. You take the party, you go and sit with the party separately, And then you go and you also talk to the other party separately. During the caucus, the father whispered to his advocate and said, look here, when we go inside there, insist that my son must acknowledge that I'm the father. That my son must also acknowledge that I'm the one who started this business. Your guess is as good as mine. When they went inside, what did the mediator say? He said, I want to invite this party to make a very important statement. And the father and the son now was told that your father has said, if you want a headway to this dispute, you must acknowledge this gentleman as your father. You must also acknowledge that he is the one who started the family business. They went outside, they discussed, they came back again, and the matter was resolved on a single day. That's how powerful mediation can be. That's how powerful this kind of an informal system can bring to the table. Now, mediation is also confidential. You can decide who can attend the session, especially if it is a financial kind of agreements, things which are relating to family. You can go into mediation, you can come out of it, and nobody else will know. And mediation normally also insists on interests and not rights. What are your interests in this dispute? Mediation can also, it also has disadvantages. Let's also look at both sides of the coin. In mediation, sometimes you find parties are not of equal strength. Your bargaining position is not the same as. It's just like a father and a son. The bargaining positions are completely different. You can also find neighbors where one of the neighbor is very powerful in terms of position in society, in terms of finances. So that is one disadvantage with mediation. And that is important. That is why it is important that the mediator must be able to balance the power, the bargaining power of the parties. Mediation can also be lengthy in situations where one of the parties doesn't want to play ball because he knows he cannot be coerced. Because you can go for mediation and you say that the session must be adjourned. And sometimes it becomes difficult. Mediation can also be non-binding to some of the parties. But mediation generally is what you'd call, it is cost-effective. You can go for a very few sessions, and you can be able to resolve the problem. It is also very informal. When you are going for mediation, you can even come and choose St. Francis here as a venue for mediation. And maybe you pay a small fee to the church for use of the facilities. But in courts, you have to contend with the fact that you have to employ a lawyer, an advocate, and some of them are not very cheap, isn't it? So mediation is much cheaper. It is more flexible. You can even have it in a hotel. You can have it in your own homes. You can have it even under the tree, so long as the parties are able to come and sit down and be able to come to an agreement. Mediation can also be a very fair way of resolving problems. So even in the Bible, there is emphasis on issues relating to peace. There is issue relating to harmony, how you should love your neighbor. So these are things that we should be able to embrace. So when you talk about mediation, normally the first place there must have been negotiations. And unfortunately, those negotiations were not successful. And then it was now promoted to mediation. But where mediation fails, also you can still have another process, and that process is called arbitration. I don't want to go there because my able colleague is going to deal with the issue about arbitration. Thank you so much for listening to me, and I hope at least I've explained a few matters relating to mediation and the benefits of mediation and the benefits of negotiation. Thank you, Church, for listening to me. This is the first time Pastor Joyce has listened to me while talking here. Pastor Joyce, I've been listening to you for all these years. Today I've had my turn. Justice Margaret Muigai, and I will go through her bio very quickly. These days with technology, you don't have to carry so many things. You can just read through your phone. Now, Justice Margaret Muigai has an LLB, that is a Bachelor of Laws degree. Justice Muigai also has a master's degree. Master's degree, that means in law. And then apart from that, she has been a magistrate for very many years. And that is why I said she's somebody I respect very much, because we work together on the bench. But apart from working on the bench, she has very rich experience. She has also worked with the Anti-Corruption Authority, and she was very senior there. And she also spent a lot of years in the Kenya School of Law. In fact, she was a senior lecturer at the Kenya School of Law. And apart from being a senior lecturer, she also rose through the ranks to become a deputy director of the Kenya School of Law. As a magistrate, she has worked in several stations. She was a principal magistrate in the High Court. She was also a senior resident magistrate at Milimani, and I know she has a very strong bias towards civil law. And also she's an expert in terms of human rights. She's also an expert when it comes to family law. She was in the family division for a long period of time, and she provided a lot of useful insights in terms of the jurisprudence in family law. She also has a certificate in world trade law. She also has a certificate in human rights. She also has a certificate in legislative drafting. So she was awarded LLM in the year 1996. Yeah? I'm sorry, that was a slip of the tongue. That was a slip. I've withdrawn that. You didn't hear that. Huh? I have the single pleasure of inviting my distinguished colleague and friend, Justice Margaret Muigai.
Thank you very much. I think you have had the most important part of ADR. That is mediation. And mine is to tell you why it is the most important. But let me start by asking, why do you attend a meeting? If you are called for a meeting, would you go? Yes or no? Or you'd think about it? You'd think about it. You would have fear, you would be worried, what is the purpose of the meeting? But eventually you would go. Why would you go to that meeting? Is it to agree? Do you expect to agree on everything? Let me say this. Mediation, negotiation, arbitration, reconciliation, all those are forms of meetings that are provided for by the law. As you have been told, the Constitution provides for it. And the reason is this. Although the court system is there, as has been explained, we have found challenges, especially in family matters. We used to go to court, advocates are present, the court is empty. Remember, family matters are private. The middle of the court is empty. One group of the family is sitting at the far left. The other group of the family is sitting at the far right. The advocates are present. And when we ask them, let us proceed with the matter, nobody wants to speak. They say everything is in the file, right? So we realized that that is not the best way to resolve disputes. And the judiciary, led by the Chief Justice, the JSC, and a body we call National Administration of Justice, which includes all the stakeholders, churches, police officers, everybody who uses the court. They decided that we should now, as courts, ask parties before we start hearings, how do you want your dispute to be resolved? And why is the judiciary accommodating and promoting ADR? It is because for a long time, the court has been the last point of call. People take the law in their hands. They kill each other, they assault each other, they destroy each other's properties. Then at that point, when they've reached the end, they now come to court. So you have in every court a dispute regarding this very family or group. But by that time, so much loss, injury, damage has taken place. So to reverse that, we want courts to be the first point of call. You come to court, whatever dispute you have, we ask you, how do you want to resolve this dispute? If you tell us, tunataka kwenda kuzungumza nyumbani, we'll only ask you, nani atasimamia? Ni mzee wa kijiji, ni mzee wa nyumba 10, ni clan ambayo itasimamia? Then we write that. Then we wait, you tell us how long it will take, and you bring us the decision, which we adopt as a court order. So that is why it is important for us to discuss these different methods, so that we are not scared that if you are called to court, sasa naenda kufungwa. No, 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 no. It is about us trying to resolve disputes. And we have had various disputes resolved. Marriages, parties come to court, and they are asked, how do you want to resolve the dispute? They say, we want to go back to the pastor who was helping us and advising us before we did the wedding. So we say, what is his name or her name? We write, and you go back, you have that session, you can come back and tell us, close the file, or we have agreed on point 1 and 2, Point 3 and 4, we want the court to determine. We have had situations where families are discussing children matters, and you know children matters are sensitive. We try as much as possible not to bring the children to court because we are trying to force them to choose one parent they cannot. Some of us parents have talked to each of the children and prepared them so that they say it is me, but the law provides that the children belong to both parents. So parties have asked that they can discuss matters children before another forum. And therefore, the court is now facilitating various methods of resolving disputes. That has been said by my colleague, but before I go to that end, there is also a form of resolving dispute that is called arbitration. Arbitration is whereby, before the dispute arises, in the course of conducting business, or trading, or having companies, you agree in a contract that if a dispute arises, this is the way we shall resolve the dispute. We shall look for a neutral expert, or we shall have an expert in this area appointed by this body. We shall sit in Nairobi, and I'll tell you why that is important. We shall apply the Kenyan law, and once the decision is made, it shall be binding. As you can guess, arbitration relates to businesses, large company disputes, government to government, company with government, and it is important that we maintain the integrity of these companies and these bodies. So, for arbitration, you must have the agreement in advance. Let me pause here and say, we are all, we want to do business, we want to prosper. But please, whenever we have a wonderful idea, when everything looks so good, let us give it one sunset. What is one sunset? Go and think about the idea. Don't sign papers. Go and think about it. Go and ask somebody who knows about that issue. If it is land you're buying, find out from the people who have bought land in that area or other experts. We have them even in our church. Surveyors, right? Find out from them. What kind of land is it? Does it have a good title? So everything, business, transaction, trade, give it one sunset. No matter how good it looks, no matter how promising it is. A contract that says that if there is a dispute, don't go to the police. Is that a genuine contract? And it is written in small print. If there is a dispute, don't go to the police. Already it is saying that there is something wrong. So as you draw those contracts, seek legal advice or professional advice, even talk to somebody else who might end up being your witness. So as you draw the arbitration agreement in that contract, you decide if a dispute arises, how are we going to resolve it? Where are we going to sit? Because where you sit, the law of that place applies. So if you're bringing onions from Tanzania to Kenya, you must agree that if a dispute arises, it can't be at the border of Kenya and Tanzania. It will either be in Kenya or Tanzania. And the law that will apply will be, if you agree it is Dar es Salaam, the law that will apply is Tanzanian law. And therefore, the experts will be appointed from, let's finish, Tanzania. That is why I talked about one sunset. Think about it. Every good deal, especially when it is too good, think about it. Give it one sunset, at the very least, before you sign off. So arbitration is valuable because you choose where and how that dispute will be heard. You even choose the person who will hear your dispute. And then why it is also very good, it is private, it is confidential, but the decision is binding. You cannot change that decision. Once the decision is made, it is binding. And all that is done, that decision is brought to court for purposes of the court helping in enforcement, right? There are situations that are provided by the law whereby you can come to court and say this decision was not properly reached, but they are very, very, very minimal. So that is what arbitration is about. We also have what my senior and colleague talked about, the alternative justice system. That is the traditional way of resolving disputes through elders, through clans, using traditional rules, as long as they are not against what the Constitution provides. So I wanted to look at the issue of family and the issue of dispute resolution as what the Bible shows us or teaches us. And one of the things that I came across is that even the families we have read about in the Bible, were they perfect? So none of us is perfect. We've all fallen short of the glory of God, isn't it? So if none of us is perfect, let us see how are those families dealing with their disputes. Let us start with the first family, Adam and Eve. We see God speaking to Adam, isn't it? Giving instructions. Adam and Eve not following the instructions. Did God stop talking to them? He continued talking to them, isn't it? Even after they had refused to follow his instructions. Even after they were told to leave the Garden of Eden, isn't it? So we also see another family, Cain and Abel. These were brothers, isn't it? One of them was unhappy about the other's offering. And what happened? He killed the brother, isn't it? Or did God just keep quiet and say, just go on? God asked, where is your brother? Then we also see the twins in the Bible. Who are the twins? Esau and? Yes, the one who came out first, isn't it? And of course, there was also a dispute. And we see God's guidance, God's intervention. And we can go on and discuss families. And does God only speak to family members? He also speaks to kings, isn't it? So we can see God speaking to David, King David, and also King Solomon. So the upshot of that is that family is God's creation. And family is God's creation with his protection and provision through communication, isn't it? Whether in good times and in bad times, isn't it? And even in the New Testament, when Jesus is speaking in the Sermon at the Mount, he also says that if you have a dispute with your brother, call him aside and explain to him, isn't it? So we can see God is involved in families, and it is for us to use the law and apply the law according to God's teachings. So each and every family, mine included, has challenges. That is the first thing we must agree on. The families we look at and admire and say, I think I admire that family. Do you know why you admire that family? It's not because it doesn't have challenges. It is the way they resolve disputes. So I know each and every one of us, myself included, we go through challenges and we feel nobody else is going through those challenges in family. That is not true. From the Bible to life today, each one of us has a challenge as far as the family is concerned. The difference is how you resolve that dispute. I'm told by those who are psychologists, family psychologists, that when a family starts, who is the one giving directions? It is the father, isn't it? Down the line, the father is getting tired, who takes over? The mother. Down the line, both of them are tired, who takes over? Huh? Children. And therefore, as time goes, we find ourselves negotiating, mediating, and reconciling with our children, isn't it? So we must keep that in a family. So to the earlier question I asked about going for a meeting, we go for a meeting for 3 reasons. 1, to identify the dispute. What I find interesting is in court, everybody wants to tell me something about them in the family, but they are not telling each other. Remember how I told you they sit? But they are very eager to tell the court, this happened on this day, this, but they are not telling each other. So how will you know what the dispute is about if none of you has ever sat down to say, I am unhappy because of 1, 2, 3. And the other person says, I am also unhappy because of 3, 4, 5. And the other one says, I am unhappy because of 6, 7, 8. That can only happen if you go for a meeting. And it can be in any of the ADR methods. You go to a meeting to identify the dispute, not to agree, to identify. Now from there, after you have said, each one of you has said what the problem is, then the next stage is to accept that this is the dispute we have, right? We find family members, for example, you ask, who are the children of so-and-so? And you're given 4 names out of 6. So you ask, what happened to this one? Because there's no death certificate attached. And you're told that one is in prison. Is he not a child of? Then you ask, what about this one? That one went with the mother. The question is simple. Who are the children of? Isn't it? So immediately you get there is a problem. And parties need to identify what the dispute is. After you have accepted, then you must decide how to resolve that dispute. And the various methods have been outlined. We do not expect that all disputes are resolved all the time to the benefit of all the parties. Notice I've used the word all 3 times. We do not expect that all the disputes are resolved all the time for the benefit of all the parties. What do we expect? That at least each one has been given an opportunity to communicate, to say what is the problem, and that each one has been given an opportunity to listen and know what the others think about the same problem. And thirdly, to see whether there are areas that you can agree. If you agree on one point, you say, we have agreed on point 1, let us take that one to court and say we have resolved. The others we can continue to discuss. And there is no calendar time that you must agree on all issues by this date. Remember, these processes are voluntary. So a meeting means that it is important for us to attend and be able to communicate effectively and listen. I know half the time we are so angry, you don't want to listen. And the other thing I'll say, this is the second last one, is that why we find it better that parties go and discuss their matters in a separate, quiet place is this, and I don't know whether at this point whether this is the right English word or words. What you have said in anger, in open space, you cannot unsay it. Have you ever realized that? If I look at you and I've always felt bad, at least it's still here. But if I say it and you have heard it, it is very difficult to unsay it, isn't it? That is the first thing. And you're saying it in public. You know, court sessions, you say you want the matters heard in public. So you have said something very hurtful. It doesn't matter whether it's true or not. But you cannot unsay it. And therefore, you have caused irreparable harm. The other thing is that once you say what you have said, since it's a public hearing, these matters can go to the press. And these days, we also have social media. Number 3, again, I don't know whether this is the right word. I find parties, every family has what we call a black sheep, isn't it? And I find that parties want to write affidavits and affidavits about this one person and how bad this person is. And what they want the court to do is to sign off that this is a bad person. There is no court that will ever do that. So I'll use the word, I don't know whether it's a proper English word. You can't unfamily one who is a member of your family. Yeah? So people come and tell you, you know, this our brother has done, I'm not saying it's only a brother, it can also be a sister. This our brother, and they give you a whole history. And let me say this about the ladies, they have photographic memories. Their story, they don't forget a single detail. So if it is a lady, sister, mother, who, the story will be concise and very long, okay? So you can't, if this is a member of the family, they do not stop being a member of the family because of who they are. And you will find, sometimes I've heard people speak as I'm passing, they don't think I understand the mother tongue language. That judge even didn't hear what we were saying. No, I heard. But I cannot say he's no longer a member of your family. And that is the law, and that is the truth. So that person remains a member of the family. And the third thing is that when there is a dispute, we are not discussing personalities. We are discussing the issue. What is the issue? The land. Whose land is it? It is for so-and-so who has passed on. Why are we having a dispute? Somebody says, I was given 10 acres, and it is normally near the road or near the river. We'll not discuss why. And the others are like, we were never told. Now, some details are so intricate. Family matters are very intricate. You cannot unravel all of them openly in an open court. In fact, half the time we don't want. Right? I remember this matter where, I don't want to say what type of matter it was. And this lady came and she had a lasso. I have a shawl. She had a lasso she had put here. So when she was called to the stand, the advocate tried to say, the matter, paragraph 4 to 5, is what we are concerned about. And the lady threw the lasso and said, mimi nataka kuanza kutoka mwanzo. And we were there for an hour. And it was embarrassing to hear some of those things. Let us not deal with persons. Let us deal with the issue, because you will still remain a family. So with those few remarks, I leave you with 2 words. 1, everything you do, if it's a business decision, family decision, whatever decision, give it one sunset. And 2, always, as much as it is difficult, as much as it is problematic, attend the meeting. Thank you very much.